and required Your Honor to order Alvin Bragg to instruct Cohen to terminate his false, greed-driven public attacks on President Trump. Oh my gosh. Was Cohen indicting some Alvin Bragg investigator? This is so inappropriate for a prosecutor and a prosecutor's office to decline to charge somebody and then release a statement that smears that person? What? They're so dishonest and disgusting people. There's no sex crime there. It's a false business records spreadsheet crime. That's not even illegal according to your own prosecutor in his book. President Trump and his defense team filed a motherload, taking it directly to Alvin Bragg, Judge Merchan, in the state of New York. This is the case that President Trump was found guilty of, those 34 different felony charges, and the media was running around saying he's a convicted felon. Well, we know that the sentencing never took place on this, and it is unlikely to ever happen now that President Trump is going to be the president again. And this is his team in an 80-page filing dropping a hammer to the court. It's very thorough. It goes through the entire history of the case and details for us just how rigged this was. And it's a brilliant filing by the incoming Todd Blanche and Emil Bove. These are the two people that President Trump nominated to come into the DOJ working directly under Pam Bondi. So you can see they both signed this right here. And that carries with it a little extra oomph, if you know what I mean, because they're going to be in charge of the DOJ very soon. Now, in addition to the brilliant filing that we're going to see, we also have Emil Bove submitting in an affirmation that there's a bunch of other stuff that we're not going to see here today. Tons of exhibits that chronicle all of the corruption in this Bragg prosecution, and they're all attached. Exhibit 8, Exhibit 10, 11, 12, 36, 37, 39, accurate copies of all the materials. So when they're being referenced, we know they can back up their words. Here's how they start this off. President Donald J. Trump to Judge Merchan, to Alvin Bragg, and to America respectfully submits this motion to dismiss the indictment and to vacate those guilty verdicts that came down against the president, saying, here's why. There's the presidential immunity doctrine, which we'll get into, the Transition Act, and the Supremacy Clause. They all require an immediate dismissal. Now, yesterday, Judge, in issuing a 10-year pardon to Hunter Biden that covers any and all crimes, whether charged or uncharged, Biden daddy asserted that his son was, quote, selectively and unfairly prosecuted, and that old Hunter was treated differently, and so his dad could pardon him. Biden argued that the raw politics has infected this process, and it's led to a miscarriage of justice. Now, these comments from Joe amounted to an extraordinary condemnation of Biden's own DOJ. This is the same DOJ that coordinated and oversaw the politically motivated election interfering witch hunts targeting President Trump by Jack Smith, disgraced Jack Smith, who's not even a real boy, and the other biased prosecutors in his office, like Jay Bratt and Molly, highlighter girl. This is the same DOJ that sent Matthew Colangelo, who was the number 3, who was the old Emil Bove, from the Justice Department into New York to lead it, to help Bragg unfairly target President Trump in this empty and this lawless case. Now, since Alvin took office, he has engaged in precisely this type of political theater that Biden just condemned in his pardon. This case is based on contrived, defective, and unprecedented legal theories relating to 2017 entries in documents that were maintained hundreds of miles away from the White House where Trump was running the country. There are no aggravating factors here other than those arising from Bragg and his own misconduct. Thus, this case should never have been brought, particularly during a period where Alvin is failing to protect the city from pervasive violent crime where people are dying all over the place. And this case would never have been brought were it not for President Trump's political views and the transformative national movement that is burgeoning under his stewardship, the political threat that he poses to the entrenched corrupt politicians in D.C. and beyond. Judge, wrongfully continuing proceedings in this failed lawfare case disrupts President Trump's transition efforts and his preparations to govern the country. Bragg's disruptions to the institution of the presidency violate the law. Local officials like Bragg, they have no valid basis to disrupt this. They also violate the Supremacy Clause as well. Consequently, the federal Constitution is an absolute legal impediment to further proceedings. And so this case must be immediately dismissed, Alvin. And this is also must be done in the interest of justice. Even Jack Smith has been forced to concede that Trump's status as president-elect mandates dismissal of his cases. Now, although Bragg has posited that they may seek to stay these proceedings during Trump's second term, sorry, you can't do that. Office of Legal Counsel already concluded you can't do that. You can't prosecute even if the case were held in abeyance. Why? Because it's going to be on the president's mind. Alvin Bragg's going to prosecute him as soon as he comes out of office. Thus, Bragg's ridiculous suggestion that they could simply resume these proceedings after Trump leaves office more more than a decade after they already started their investigation is not an option. So you're not holding on to this case until he gets out. Now, consistent with the course of ethical conduct that is unethical conduct, dating all the way back to Jack Smith's November 2022 appointment, the special counsel intentionally and improperly failed to memorialize the legal counsel's reasoning or to have them memorialize their reasoning regarding these historic or unprecedented matters. But nevertheless, right, so Jack initiated his prosecution and then didn't memorialize the rationale for the prosecutions. Now he's reversing himself. He's like, oh, well, there's another rationale. But nevertheless, whatever Jack did, whatever. There is nothing about this prosecution in the Alvin Bragg case in New York, driven by Bragg, a local prosecutor whose actions threaten to interfere with the federal government. Sorry, the Supreme Court and the Transition Act, and the OLC, the legal counsel memo, also apply here. It applied to Smith. It applies to you, Bragg. Now, Bragg also conceded as much in the Trump versus Vance immunity case, which was going up on the January 6th docket out of Chutkan's courtroom, which concerned early aspects of the investigation that gave rise to this case. There, Bragg acknowledged that when a state attempts to regulate the federal officials' powers, they can be mindful, but they did acknowledge, Bragg already wrote in a prior motion, okay, we know we cannot prosecute a president while in office. He already conceded that in a prior filing, already said it would be a real burden. And so that's what must happen now. He already admitted it. And so they have to stop now because they've already said, once you're the president, it would be a burden, but Trump is not the president, so we can prosecute him. Well, now he's going to be. Many other considerations mandated a dismissal here. Alvin Bragg's politically motivated targeting was not limited to Trump, okay? Conroy, who was also in Alvin Bragg's office, participated in the blatant and unconstitutional prosecution of Paul Manafort. And they also tried to take out Steve Bannon. Now, from the outset of this investigation, Alvin Bragg engaged in a prejudicial and highly improper pattern, leaking secret information to the media. Then, remember, we had Mark Pomerantz, whose book contained information so sensitive that Bragg told a federal court that the disclosures subjected a prosecutor to criminal exposure. Wow, I didn't realize that. Now, it speaks volumes about the repugnancy of Bragg's behavior that Pomerantz refused to even answer the question. Why can't you answer this question, Mark? Did you knowingly break any laws when investigating President Trump? Did you? Yes or no? Easy. No, of course not. I'm a prosecutor. I have a badge and everything. Whatever, okay? They all love themselves. Ridiculous. Bragg ran for office based on his promise to continue targeting Trump. Bragg's persistent efforts to make good on that promise while conditions in the city deteriorated and people are now being shot in the head. Did that happen in New York today? People are being shot cold blood on the streets? I think it was, right? Yeah, it was in New York today. Great. Coupled with his improper extrajudicial statements after the charges were filed, created numerous appearances of impropriety in Bragg's front office. Bragg's line prosecutors carry out a similar pattern of misconduct. They lied, they'll call it misrepresentations, we'll call it lies, to a federal court in connection with removal proceedings. They incarcerated Alan Weisselberg, okay? Alan Weisselberg was a 70-year-old man who they said lied because he didn't testify the way that they wanted him to. While at the same time, they didn't investigate any perjury by Michael Cohen, who is a convicted perjurer. In addition, because he said what they wanted him to say. So they throw a 70-year-old man in prison. Michael Cohen runs free, lying through his mouth all over the place. In addition to that non-prosecution benefit, additional indicia of an improper relationship with Cohen, which led to a discipline of an Alvin Bragg investigator. Whoa! Who's that? And required your honor to order Alvin Bragg to instruct Cohen to terminate his false, greed-driven public attacks on President Trump. Oh my gosh. Was Cohen indicting some Alvin Bragg investigator? Improper relationship? The hell does that mean? I don't know what that means. We know what that meant during the Clinton times. But anyways, misrepresenting to the court that Weisselberg was unavailable to testify based on his severance agreement when they never even tried to bring him to court. Why? Because they had to target Weisselberg. They had to turn him into a perjurer because he was going to come in and directly refute Cohen. Cohen was a convicted perjurer. So Trump's defense was going to say, well, you got a liar over there. So they needed to say, well, you have a liar over here too. So they manufactured a perjury charge against the guy and then put him in prison just to get Trump. They're sick. Brazenly violating the court's admonishment during the testimony of Stormy Daniels, who suddenly during the trial, it was now in this new idea that she was like Trump was standing over her, like she was under attack or something. The heck? You're a porn star. Eliciting perjury from Cohen at the trial because he lied again. So the list is just horrific. And we're going to zoom even in further on this. I mean, this gets intense. Now, nor can it be overlooked insofar as the law is concerned that this court has insisted, this judge has insisted you on presiding over these proceedings despite substantial appearances of impropriety and conflicts of interest. This is the incoming DOJ Assistant Attorney General speaking, Judge. I'm talking to you directly. These circumstances include the court's improper financial contributions to Joe Biden, Trump's Trump's opponent made $35 donations to him in violation of the judicial ethics rules, okay, Your Honor? Your Honor's daughter also publicly expressed bias towards President Trump and publicly recounted a conversation with you, Judge, that she talked about on a podcast where the court expressed similar views that were consistent with your financial contributions. So not only do we know that you donate to stop Trump because you donate to Biden and you donated to, like, Save American Democracy or whatever that was, which is a Democrat organization, then your daughter goes on a podcast and says that daddy doesn't like Trump's tweets. All right, so you're going to be fair and impartial? Judge Mercan? No. Your Honor's daughter has a long-term personal, professional, and a very lucrative financial relationship with Kamala Harris, which included a senior position on Harris's failed presidential campaign because she was raising money for him. Now, Your Honor's daughter is now a part owner and a senior executive at Authentic Campaigns, which has publicly mocked President Trump and created marketing efforts while they were working for Kamala's failed campaign. Authentic has received tens of millions of dollars from President Trump's opponents. It's money laundering, in my opinion, to the judge through the daughter from Democrats. Hire the judge's daughter's company so that daddy will incarcerate their political opponents, as transparent as can be. And those Authentic clients have solicited huge sums of money based on the case itself. Shifty was posting Facebook messages saying, Trump just got arraigned in New York, donate to me. After the trial was completed, during a period when there was no risk whatsoever to the integrity of the remaining proceedings, the court continued to violate President Trump's First Amendment rights and interfered with his ability to communicate with voters via a gag order. Remember that? That still prohibits Trump from addressing these matters of public concern on threat of jail. Now, these circumstances, among others, are now the subject of a congressional investigation, Judge. On September 27th, the House Judiciary Committee notified counsel for Mike Nellis, a partner of your daughter, who's all over X, of non-compliance with a congressional subpoena, and said that the prospect that Nellis made false statements to the committee. Wow, lied to Congress. Now, as Biden put it yesterday, enough is enough, buddy. This case, which should never have been brought, must now be dismissed. Should the court disagree and plan to issue a decision pending our other motion, or if you even decide to schedule a sentencing, President Trump respectfully requests notice of those determinations and a 2-week stay to provide a reasonable opportunity to pursue federal injunctive relief. They're not playing around, all right? Very, very serious. Now, here's the background. Alvin Bragg's unconstitutional targeting of President Trump began a long time ago. Alvin Bragg began their crusade against Trump in August 2018. We rewind the clock a minute. While he was serving his first term in office and while Trump was protected by presidential immunity. Even the Judiciary Committee says they targeted him. The entire case was politically motivated and unethically brought. In fact, here's how it went down. Former Special Assistant DA Mark Pomerantz, who we've talked a lot about here, his colleagues dubbed the focus of the charges, right? They called it the zombie case because of how many times Alvin Bragg abandoned the theory. In fact, before Alvin came in, somebody else was in charge of it named Cy Vance. Didn't think there was anything there either because there isn't. They kept reviving it after another inquiry died off. There he is, Kerry Dunn. Counsel to Cy Vance at the time recruited Pomerantz, right? They put together their little anti-Trump dream team there and they focused their whole lives on, quote, the investigation of Trump because they got nothing better to do. In Pomerantz's, quote, inside account published after he resigned because he threw a fit, Pomerantz disclosed the unconstitutional bias that drove Bragg's office's tunnel vision against Trump. Pomerantz believed that President Trump was different, said Trump had been elected by the American people, he would have a continuing presence, and his, quote, behavior made Pomerantz, quote, he wrote this in his book, angry, sad, and even disgusted. So Pomerantz was delighted, right, because he's a partisan hack, to help Alvin Bragg for free. Didn't even want $1 because he felt that Trump was a good target for prosecution on whatever charges they could concoct. Show me the man, I'll show you the crime. Lev Beriev, Stalin's chief of the secret police, personal police. The fact that a senior Bragg prosecutor, even before Bragg came in, because Bragg took this case over from Cy Vance, he believed that Trump should be subject to different, far more hostile treatment under the law. After Bragg announced his run for DA, he made improper targeting of President Trump a key part of his campaign. He attacked Trump every chance he got. He emphasized, he says, I sued President Trump more than 100 times. Bragg promised he had more experience with President Trump than most people in the world, and that he would hold President Trump accountable. Exhibit, exhibit, exhibit. In March of 2022, more than 1 year before the lawless indictment was filed by Bragg, Alvin Bragg's wife boasted about her husband's progress towards a campaign promise by reposting on social media, Mrs. Alvin. She said, oh, finally, a bit of good news in the Manhattan DA criminal case against Donald Trump because my husband nailed President Trump on felonies, because they got nothing something to live for in their lives other than just targeting Trump. In April 2022, the media confirmed that Biden was actively encouraging the prosecution of Trump. Biden had confided, they said, this was reported, remember, I think it was from the Times, that he confided to his inner circle that he believed that Trump was a threat to democracy and that Trump needed to be prosecuted, saying Biden has said privately that he wanted Garland to act less like a ponderous judge and more like a prosecutor who is willing to take decisive action. So do something. So then guess what? On November 9th, President Trump said, I'm going to run for president, more or less. And Biden came out and he gave that clip. You've heard him say this many times. We've played it here. Biden came out behind that podium. He says, we just have to demonstrate that he will not take power if he does run. I'm making sure he, under legitimate efforts of our Constitution, does not become the next president again. Then on November 15th, Trump formally announced. Then 3 days later, fake Jack Smith, an illegal prosecutor, was illegally appointed, was never formally appointed by Joe Biden, is not a U.S. attorney, was never confirmed by the Senate, failed all the special counsel statutes. That's why his case was dismissed in Florida. Now, less than 3 weeks after Smith was appointed, Alvin Bragg then created a completely new position at his office. Isn't that fun? Announced that he was going to fill it with Matthew Colangelo. Colangelo is a senior official at the DOJ. And he put a press release that we read here. We connected the dots, follow the bouncing ball, saying that he was going to come in and work on high-profile white-collar investigations, aka Trump. The claim was patently false. Following Biden's pressure on Garland, Biden's DOJ sent Colangelo to Bragg's office for the sole purpose of targeting Trump in a new forum. They launched attacks in multiple jurisdictions. Jack Smith took the 2 federal jurisdictions, D.C. and Florida, and lower-level state prosecutors took Georgia and New York. Similarly, apart from this matter, the only other press release about Colangelo is one that relates to Harvey Weinstein. The DOJ sent Colangelo to Bragg's office for one reason alone: to target President Trump, no matter how they had to do it. Now, as this all began, we remember there were a whole slew of leaks, coordinated lawfare with the Biden administration, leaking stuff time after time. Between at least 2021 and 2023, tons of leaks. Washington Post saying Trump's going to get indicted. There's a special grand jury. November 24th, 2021, Trump's investigation entering crucial phase as prosecutors' terms nears an end. Then Bragg reached a conclusion February 22nd, and so they're leaking it 11 months later. New York Times, Politico's reporting stuff. Mark Pomerantz, that hack prosecutor's leaking stuff all over the place. More than 3 years after the investigation, Pomerantz was appalled and perturbed to learn that the Bragg prosecutors were going to question whether they should prosecute Trump. Pomerantz grew frustrated. He said, there are people in here that are trying to bring these cases against him and they're not successful, so he's losing his mind. Then in March, Pomerantz, like a little baby, resigned from Bragg's office, claiming that Bragg had decided not to proceed with charges, so I'm out of here. His leaked resignation letter, which I would guess, if I had to speculate, it would be he leaked it or someone close to him released it, had several misleading and inconsistent statements. The letter focused entirely on charging theories that Bragg never pursued, made no reference to false allegations about hush money payments, and saying that Bragg felt deeply stung because Pomerantz scolded him. It was an unusual public statement. Remember, it was all over the place. We're like, this is so inappropriate for a prosecutor and a prosecutor's office to decline to charge somebody and then release a statement that smears that person. What? It's misconduct. It's unethical. He shouldn't have done that, but it's New York. They don't care. So then he releases the statement and Alvin Bragg gets scolded into resurrecting the zombie case. Less than 2 months before Alvin Bragg authorized the actual charges, Pomerantz leaked an extraordinary amount of confidential and protected details. He wrote a book, Pomerantz, Inside Account. His leaks were so egregious and harmful to Alvin Bragg's case that they argued to a federal court that the book contained information that should not have been published. Yep, and should not have been exposed. That now exposes Pomerantz to criminal liability under the city charter. Whoa! The city charter says, well, at the time the book was published, the proceeding that we were trying to protect was confidential. We had a legal obligation to maintain the grand jury secrecy. Wow, there's grand jury material in there. We tried to navigate the best we could. We sent the letter, but the book was already published. The city charter I'm referring to are these sections. It makes it a misdemeanor to violate that, which says a former employee may not disclose confidential information. Oops. So he had to invoke his Fifth Amendment because he broke the law, allegedly, to release those records. The question comes out, sir, did you knowingly break any laws when investigating President Trump? Oops, doesn't want to talk about it now. Wrote a whole book about it, but now doesn't want to talk about it. Here are some other statements by him. He said the facts surrounding the payments did not amount to much in legal terms. Yeah. Paying hush money is not even a crime, even if the payment was made to help a candidate. Okay, so thank you. He also said creating false business records is only a misdemeanor under New York law, but they charged him with 34 felonies. There appeared to be no felony state crime in play. There never was. To charge Trump with something other than a misdemeanor, Pomerantz said this: Bragg would have had to argue the intent to commit or conceal a federal federal crime, converted the false into a misdemeanor. Converted it into a misdemeanor because there was another crime, and he had the intent to commit another crime. What's the other crime? Whatever you want. Pick a crime, any crime, doesn't matter. No appellate court has ever upheld that. The statutory language under which Trump was charged is ambiguous. There was a big risk that felony charges would be dismissed before a jury could even consider them. The Trump investigation should have been handled by the DOJ. It was investigated and they rejected it. Should have been handled by Bragg. Federal prosecutors, this is in this guy's own book, federal prosecutors would not have to torture or massage the statutory language called the law to charge Trump, as Bragg does. Federal prosecutors previously looked into Stormy porn star Daniels' hush money payment, and they didn't move forward with it. And the statute of limitations is a problem in this case. The statements go on, okay? So even Pomerantz knows this case is not appropriate. They discuss Cohen's credibility as being one of the difficulties of the case because the guy is a bona fide liar, lied in the Letitia James trial. At one point, Bragg commented that he could not see a world in which they would indict Trump, calling Michael Cohen as their star witness. It's a joke. Now, Bragg's improper prejudice to the jury pool. There were also leaks, and his star witness, called Michael Cohen, was also running his mouth. A pretrial survey said that negative publicity against Trump means there is no chance that he could ever get a fair trial in Manhattan. Of course not, because it is blue. At Bragg's press conference, when he announced the charges, he made a gratuitous and prejudicial reference to matters involving sex crimes. Did he say that? Which had no relevance at all, but he wanted to say there was some sort of a sex crime possibility with Stormy Daniels. They're so dishonest and disgusting people. There's no sex crime there. It's a false business records spreadsheet crime. That's not even illegal according to your own prosecutor in his book. During a radio interview, despite the court's acknowledgement, he talked about it. Bragg made statements indicating that they rebranded this case to align with Jack Smith's case. Wow. So he was colluding with Jack Smith, who was illegally appointed. So he's a co-conspirator. Bragg stated that the new theory was not money for sex, obviously, because they'd have to indict everybody. Bragg would instead echo Smith's ill-fated and unsupported theory about conspiring to cover up a corrupt election. Then they targeted Alan Weisselberg. Remember that? We covered a lot of that story. Then Michael Cohen came out. Following the announcement of their charges, Michael Cohen, the convicted perjurer, sought financial benefits based on the status of this case. He was like a media darling. For some reason, they love to be lied to. It's the weirdest thing in the world. Democrats like it when they lie about Joe's competency. Then they like it when they get lied to about Kamala's competency. Then they get lied to about Joe Biden being an honest man who would never lie to them about a pardon. Then they get lied to again. And they're still defending him. It's like absolute lunacy. But then Michael Cohen, who is actual liar, adjudicated, they bring him on the show. Cohen released more than 160 podcasts during Trump's case, including a public declaration that Cohen says, "I'm not intimidated and I'm ready to strike back." Other Cohen podcast titles, he says, ex-FBI agent tells Michael Cohen why Trump is screwed. That's a good title. Former top DOJ prosecutor says Trump is screwed. It's okay. Well, it's kind of repetitive. Reveals all to Cohen. Prosecutor who investigated Trump hits him with crushing blows. Michael Cohen pounces. Okay, Michael. You're not pouncing anywhere, brother. Now, in a February 15, 2024 interview on CNN, Cohen claimed to be speaking on the basis of non-public evidence that Alvin Bragg had. Okay, Cohen was saying this: "I believe, based on information that I know, and based upon not just the documentary evidence, but the corroborating testimony from many people, I believe that he'll be found guilty on all charges," says Cohen. During a March podcast, Cohen made false and defamatory references to Trump, called him a monarch, called him a dictator, called him Fuhrer, called him supreme leader. Cohen also lied about President Trump, saying he's going to use SEAL Team 6 to incarcerate judges and politicians. He said, "We need to bring these billionaires to him, and he's going to do what the Saudi Arabians did." Whoa! Cohen said he hung these MFers up. Whoa, Cohen. Cohen spewed similarly prejudicial claims to his more than 600,000 ex-followers. Not to be outdone, Stormy Daniels sought to monetize her role as well. So the porn star is like, "Oh, I want to get in on this," like she usually says, as a witness through a short-lived podcast and documentary. Remember her? Stormy? NBC Universal put together. They love like degenerates. Like, we're going to do a whole documentary on her. Incredible. Was released in an effort to maximize views and prejudicial publicity. Remember, they timed the release of her stupid documentary, Stormy. She's like riding around in a pickup truck, like through the meadows. And during the evening of March 7th, the media reported that Daniels was releasing a documentary. Peacock, which was the perfect platform for her, as we commented on, released a 2-minute and 12-second trailer the same evening, which included Daniels describing herself of out of F's, and she's an idiot who can't keep her mouth shut. Yeah, that's for sure. She claimed in the trailer that S got real when President Trump got the Republican nomination. Well, now he's going to be the president again, Stormy, and read highly prejudicial threats not connected to President Trump, such as a random person allegedly stating, "You just signed your death warrant." A male associate in the documentary claim says that unspecified people with no connection to President Trump tried to bring guns and knives into Daniels' events. What does that have to do with him? The trailer ended with an effort to bolster Stormy Daniels' anticipated testimony through the claim that she won't give up because she's telling the truth. On March 8th, Daniels screened her documentary at a conference in Austin. She used the platform to declare F Trump. Then, on March 12th, for the first time, Alvin Bragg's office disclosed that Stormy made $125,000 for that documentary. Isn't that nice? NBC just funneling her $125,000. The documentary premiered in Brooklyn on March 18th, was released on Peacock the same day. It contained additional highly prejudicial and false claims, including Daniels' claims that she had sought to extort money from President Trump because she was effing terrified. Said people had been suspiciously killed for political reasons. Yeah, I mean, the Clintons do that, yeah. There would be a paper trail and money trail linking me to Trump so that he would not have me killed. Okay, so she basically admits, yeah, I tried to grift him for money so that he wouldn't kill me. That's why I did it. Now, in addition to those two total losers, Cohen and Daniels, who Democrats love and had on their podcast and paraded around, Alvin Bragg committed misconduct in the trial. Actual misconduct in violation of the law. A prosecutor for Bragg's office called Susan Hoffinger repeatedly and wrongly elicited false info from Stormy Daniels intended to suggest that Daniels' made-up encounter was non-consensual, okay? So Stormy's story goes from Trump hired her, paid her some money to pay her off for a one-night stand or something, turns into an abuse case, all right? An assault case, non-consensual. He was standing over her. The court, the defense was objection, Your Honor. What? The judge sustained objections and did strike certain aspects of the testimony, but Hoffinger persisted despite the court's admonishments. And you can see the transcript there, that page, and those two pages, and that page right there. She did it multiple times. In response to President Trump's mistrial motion, the court even acknowledged, in an understatement, the court said there were some things that probably would have been better left unsaid, and that there are some areas that would have been better if the people did not go into them, but they did. The court also explained that Susan Hoffinger, the prosecutor, had elicited other objectionable testimony as well. And at one point, the court sua sponte objected on their own, which means the court did it, right? The court just volunteered. Then in December, we also know in 2023, federal prosecutors argued publicly. They said in a filing that Michael Cohen appears to have lied under oath in a court proceeding because he told a federal judge one thing and a federal court agreed. They said the record gives rise to two possibilities, okay? One, Michael Cohen committed perjury when he pled guilty in federal court in front of Judge Pauley. Either he lied there or he committed perjury in the trial brought by Letitia James, where they also dragged him there for the civil fraud case. Now, during the same period in which Bragg was coercing Alan Weisselberg to plead guilty so that he could be a perjurer, prosecutors ignored the federal court's findings and they refused to even investigate Cohen. Okay, they prosecuted Weisselberg for some fake made-up perjury charge. A federal judge said Cohen is a liar and they didn't care. Now, Bragg needed more lies from Cohen and they wanted to discredit and detain Weisselberg so he couldn't hurt their case. These are sick people. They did that to a 70-year-old man who did nothing wrong. Now, at trial, Susan Hoffinger structured Michael Cohen's direct exam when she was asking him questions based on leading questions tethered to purported evidence without any content and like cherry-picked phone records. Now, Michael Cohen played along. He committed perjury yet again. He lied about a 1-minute, 36-second phone call. The direct examination was about his phone call with Trump about a payment to Daniels. Then, during cross-examination, remember, he said, I talked to Trump about Stormy Daniels. They said, no, you didn't. You called Keith Schiller because there were teenagers harassing you. You remember that? Now, to our knowledge, Cohen has only received hugs, handshakes, and pat on the back from Bragg. His perjury goes unpunished. Now, Alvin Bragg also lied about Alan Weisselberg's severance agreement, and he lied about removal proceedings, saying Bragg argued that there was no connection between some of the legal components of the case, and so you cannot take this up to federal court. The district court at the federal court relied on Alvin Bragg's false representations, saying Alvin said, we're not going to use any official presidential acts. We're not going to talk about anything that could be immune. Of course not. And so there is no federal issue here. So the federal courts rejected. Well, turns out Alvin Bragg talked about all those things. And so he lied to them. Now, there is much more, as you can see. Your Honor, we're not done with you and your daughter yet there. Your Honor's daughter was a senior member of Harris's failed 2020 presidential campaign, and she made social media posts mocking Trump when he left in 2021. And in 2019, your daughter discussed a conversation that she had with you that involved criticism of Trump's use of Twitter, now X. Now, in 2020, Judge, while President Trump was in office, your Honor made improper political contributions to Biden for president, and there it is, Progressive Turnout Project, and you donated to Stop Republicans, a group that is built to resist the Republican Party and Donald Trump. Now, New York's ethics authorities issued a caution based on those contributions, which was a violation of conduct. And based on those disclosures of your donations and your daughter's work, she actively advocated against President Trump, and she got political contributions based on this case that you ran, Judge. Authentic clients, including those who are soliciting money, dispersed more than $18 million since this case began. Authentic, your daughter, even was posting happy birthday messages to Kamala Harris. Look how far we've come. So then this summer, after Harris emerged as Trump's opponent in 2024, Harris immediately framed her candidacy with a specific false reference to the case. She called herself the prosecutor versus the felon because Trump was found guilty in New York. And a lot of people will say, well, since he was found guilty, that makes him a guilty felon. And I would say, well, the conviction matures and crystallizes itself at the end of the sentencing. And if Trump is a convicted felon, how did he go and vote in Florida this last election cycle if he is a felon? I don't know how he voted if he's a felon. So subsequent to President Trump's renewed recusal motion relating to these issues, an FEC filing by Harris's campaign demonstrated that Harris was a direct client during the election that she recently lost. In fact, on August 1st, the House Judiciary Committee sent a demand for information to your Honor's daughter. They wanted to know more about this relationship, saying that your failure to recuse yourself is a big problem. The Judiciary and Congress noted that experts say there are concerns here. Your daughter is working for his opponent. Your daughter and you guys at Authentic work for Schiff and a Senate Majority PAC. They raised $93 million. In August, a notice and subpoena was sent to Mike Nellis, who works with the judge's daughter. The Judiciary Committee said during Miss Mercan, the judge's daughter's employment, Authentic got $7 million in compensation. Daughter gets paid, daddy does the dirty work. Now, while your Honor's daughter and Authentic have transparently limited their social media presence, Nellis has amplified the type of bias that any reasonable observer would expect, and he does talk a lot on X. Around the same time as the Harris campaign, Nellis created a group called White Dudes for Harris, right? And he looks like the perfect caricature of a white dude for Harris, like perfect, fitting. Now, which reportedly raised millions of dollars despite losing badly. Nellis recently received a Shorty Award titled Strategist of the Year for his support of that losing effort. Man, what a failure. Now, in his acceptance speech for losing so badly, as well as in a related post on X, Nellis called for acts of resistance against President Trump and urged his followers to stay in the fight. Similarly, on the day before Thanksgiving, he said, "We need to stretch the limits of what's possible. We need to be more aggressive. We need to be ruthless," like putting pressure on the judge to incarcerate him. And now let's talk about this gag order that apparently Trump's defense team doesn't give a rip about anymore. Says since the end of the trial, the court has insisted on a gag order that is unprecedented and unsupported by Bragg's legal theory. The court has acknowledged, as it must, that the witness testimony has concluded, a verdict has been rendered, and the jury has been discharged. But nevertheless, the court has prohibited President Trump from making public statements addressing his valid concerns about the conflicts and appearances of impropriety, about Matthew Colangelo, and the financial, professional, and personal benefits your Honor's daughter has obtained based on the court's rulings in this case. So here is where they're acknowledging that Trump cannot make the public statements. So we'd have to revisit that secondary order. Did that order say the attorneys cannot make statements, or was it only President Trump? Because I feel like it was Trump and his people. But regardless, the attorneys, as you can see here, are hammering the daughter, and rightfully so. But yes, as it stands, the defense team is admitting that from their perspective, Trump is still gagged at this moment, still from making these statements. Now, on July 1st, the Supreme Court issued a presidential immunity decision, and Bragg refused to wait for this, and he violated the case. Let me say he should have waited, because remember, in the immunity issue, Judge Chutkan stayed the case. Jack Smith was not allowed to file anything while the Supreme Court and the Court of Appeals settled this. Alvin Bragg didn't follow that same pattern. The judge didn't follow it. They just kept everything going, and they trampled all over over Trump's immunity. But he preserved that right, and they dumped all over him anyways. Now, all that being said, President Trump, in spite of all of that lawfare, still returned an overwhelming victory in the 2024 election. And you better believe that, Judge Mercan. On November 5th, the American people gave President Trump a powerful national mandate to make America great again and to address the harms perpetrated by the Biden-Harris administration, including their unsuccessful lawfare using Bragg's office and Jack Smith and others like Big Fanny. We'll get to her next tomorrow. President Trump won 312 electoral college votes compared to Harris's 226, obliterated, and he beat Harris in the popular vote by 2.5 million votes. White dudes for Harris. President Trump is now fully engaged in the transition process, and Congress will certify President Trump's victory on January 6th. President Trump will be inaugurated on January 2025, and he's going to be your favorite president again. They say on November 25th, Jack Smith moved to dismiss the prosecution against Trump and to dismiss the appeal in their already dismissed case from Florida, the classified documents case that was dismissed on the basis that Jack Smith is illegal. And the special counsel informed the federal courts. He said, well, I talked to the Office of Legal Counsel, and they said that that old opinion was a categorical prohibition and that we can't even pause this case, and so we have to dismiss it. They said it only applies to the federal cases, and when they wanted more information about, hey, what did the OLC's opinion say? They said, wait a minute, you talked to them? What'd they say about this? Because we're going to take their opinion and shove it down Alvin Bragg's gullet. Oh, they said, oh, it was just a phone call. It was orally, not in writing. Yeah, so you just like, what, you talked on the phone? No, you didn't. Jack Smith is running and hiding, and he's trying to get rid of this as quickly as he can. This intentional and unconstitutional decision to avoid creating a paper trail when they're reaching this decision in conclusion, all of which could be exculpatory, is additional evidence of their misguided approach to their improper work. So you're saying you got a legal opinion from another government agency that told you not to bring this case? Now, the Presidential Transition Act as well is another thing. Trump's transitioning in. There's rules. When you're transitioning in, the Constitution recognizes the states have no power under the Supremacy Clause to hamper that transition. Even subpoenas could be considered harassment. And so to protect against these things, we invoke the Supremacy Clause as we've done here. Lots of cases being referenced. Now, in discussion of why this all, based those facts and those rules, we're going to apply the rules to the set of facts that we just analyzed and do some analysis. Here's what they say. As a result of the election and these timely motions, Trump's status as the soon-to-be sitting president is a legal impediment to this case, and it must be dismissed. Immunity requires dismissal. The sitting president is not subject to criminal proceedings as a defendant, and Trump just won. This consideration is dispositive. You must dismiss this case. If you allow it to continue, it is unconstitutional. It's a danger that has been long recognized. There's a categorical rule against criminal proceeding targeting a sitting president. It's so firmly rooted that they hardly even talked about it in that upper level case. Late last month, Jack Smith's office confirmed. They agree. Yeah, shoot. They said it's categorical. We have to dismiss this. The OLC's prior conclusions confirm and agree with this. Each of the three burdens analyzed by the OLC, they said a president might be subject to potential incarceration, to stigma, to diversions of attention. It's why it must be categorical. You can't do it. And third, criminal litigation requires personal time and energy as well. Stuff that the American people have said is better used governing the country. Now, finally, while categorical immunity shields Trump from criminal proceedings, the Supreme Court has said that alternative remedies and deterrents that establish absolute immunity don't place the president above the law. Impeach him if you think there is a problem, like they should have done in the first place, but they never did. So in sum, presidential immunity means you must be immune. And that's what we're asking for here. The Presidential Transition Act confirms the same. So does the Supremacy Clause. We don't want a nightmare scenario where Fannies and Alvin Braggs can prosecute people willy-nilly. Bragg knows this is true. They have been unwilling to say that this is true for political reasons. They know there are problems with separations of power, and they're burdening the presidency, and they know they're doing it. So there are other reasons we should dismiss this. Office of Legal Counsel gave a whole bunch of reasons. They're talking about statute of limitations and more. And you can't just delay these cases until the end of Trump's second term either, because he'll have to be thinking about all of that. The deferral that Alvin suggested is also against the OLC. And so under the law, this case must be dismissed under New York law. The underlying records entries, they don't rise to the level of any crimes that are felony offenses. He's increasing the criminal culpability without any cause. His failure to charge anyone else in connection with this scheme says there's no serious misconduct here. The federal government declined to pursue charges against Trump, and Cohen, they said, might actually be criminally liable for other things. So there's no seriousness in these allegations, and there's no harm anyways. The Trump organization didn't make any money. They didn't defraud the government. They paid their taxes. There's no false information on their 1099. Nobody got harmed at all. The business records at issue, nothing withheld information from voters. The claims here about McDougal and other things, they're false claims. They were already made public long before the election anyway, so nobody was paying somebody off to cover this up. All of this stuff, the allegations about McDaniels and McDougal and Stormy, they were all released before the election anyways, and the evidence in this case was extremely weak. They tried to bolster Cohen's account. They resorted to a myriad of violations. They wrongfully emphasized this inadmissible evidence, which was all of Trump's official acts during his first term. They told the jury that what Trump was doing in the Oval Office was damaging and devastating, but they couldn't talk about those things, and they did. And by the way, Trump has been somebody who's been of extraordinary service to this country, and he's being targeted with political and prosecutorial misconduct. While Bragg was campaigning, he actively attacked and targeted Trump. He was the elected prosecutor, and he ran without a manner of basic fairness. Pomerantz should be disciplined. He may have even broken the law. Now, after the charges were filed publicly, Bragg made additional improper extrajudicial statements, and they ignored Michael Cohen's perjury. By the time trial got around, New York prosecutors were willing to say and do anything to take out Trump. Bragg's hubris on the topic and their stubborn insistence of offering immune evidence resulted in damage to the institution of the presidency. Conroy misrepresented to the court that Weisselberg was unavailable to testify. Hoffinger wrongfully used Daniels, the porn star, to lie or to suggest to the jury that the act was not consensual, if it ever happened at all. These were desperate efforts, and the prosecutors manipulated this accordingly. Pre-trial polling substantiated significant concerns. 77% of New York respondents have a negative opinion of President Trump, so there's no way he gets a fair trial here. And lastly, we recognize without conceding that Your Honor's conclusion that this court has not faced a disqualifying conflict during these proceedings, we recognize that you've decided that. Nevertheless, the public sees things differently. Your Honor violated applicable ethics rules by providing financial support to Trump's opponents. Your daughter publicly criticized Trump, including specific issues about using X. She worked for Kamala. She's got personal financial entanglements. She's made tens of millions of dollars working for Trump's opponents. And those people are making money off Your Honor's handling of the case. Within weeks of Harris announcing her candidacy for president, they disclosed a direct payment to Authentic for your daughter's services. Nellis, your daughter's partner, raised a ton of money for Harris, and he wants people to fight, be aggressive, and be ruthless. Now, it would be a Herculean, and we respectfully submit impossible task to remain impartial under these circumstances, Your Honor. We know you may have tried, but you can't. Dismissing this case rather than continuing this course of action up to the Supreme Court and others would improve the public confidence in your judicial system if you'll just do the right thing. Now, there are no victims here. The community at large is not a victim. McDougal, Daniels, they're not victims. The public suffered no harm. There was no crime here. McDougal didn't even want to publicize her story. She negotiated with AMI for a payment, and Pecker accommodated her. And Daniels, Stormy, the porn star, isn't a victim either. At best, she entered into a contract with Cohen that resulted in an exchange, a bargain for contract. As her attorney put it, she sought to extort President Trump. She sought to extort her campaign by exerting her leverage relating to a date uncertain. She says, well, if he loses, and he's going to lose, all the effing leverage in this case is worth zero if he loses. And if that happens, I'm going to sue you because you lost this opportunity. We know we're full of S in the media. We know that she was never threatened in Las Vegas. We know all these things, is another quote. So there is no victim. There are no additional proceedings that may take place. Your Honor, if you think you're going to schedule something else in here, better think again. It should be unnecessary to address those additional violations. Otherwise, you're acting outside of jurisdiction. Look at this. In no event, they're telling the judge this, in no event may the court proceed to sentencing. Don't even think about doing it. You want to reschedule a sentencing date? Not happening. In addition to presidential immunity and the supremacy clause, federal law prohibits the court from entering a judgment of conviction until the appeal is resolved. Sentencing is the entry of judgment in a criminal case. Until then, there is no judgment. Judgment is complete when the sentence is imposed. So there you go. Okay, they're citing New York law, CPL section 1.2015. Judgment is complete when the sentence is imposed. The judgment is not complete. Therefore, the court lacks authority to take steps prior to the resolution of this. And if the court disagrees and you schedule a sentencing, we ask that you delay that for 2 weeks to give us notice, because we're going to take this up and get a federal injunction on you. So let us know what you decide to do. But the only thing you can do is dismiss this case. Signed by the incoming becoming Deputy Attorney General Todd Blanche and the Associate AG Emil Bove. Ooh, baby, that's a good one. So shout out to those gentlemen for that amazing filing. We're going to be here continuing to cover this. We'll see what Judge Merchan does. We'll see if Alvin Bragg responds to this, and we'll be waiting a dismissal right here. We hope you join us when we come back and it's gone.